The Constitution of India prohibits any kind of discrimination as under Article 14 of the Constitution. There is a right to equality. So it is equality before law and equal protection of law. Besides this prohibition, even under Article 15 and Article 16, the Constitution itself also provides certain kind of discrimination under these articles in respect to educational institution and also in case of employment. And in this regard, we found the very idea of protective discrimination as it was developed in the Karachi session of Indian National Congress in 1931, which indicated regarding socio-economic and political equality, and that socio-economic political equality what dreamed at the Karachi session could only be possible by incorporating certain direct principles of state policy under Part 4th of the Constitution, and that idea of direct principle of state policy for providing social justice, economic justice, and political justice. The idea was enshrined in the Constitution of India in 1950 when it came into effect under Part 4th of the Constitution. So, Part 4th of the Constitution, which aimed at socio-economic and political justice, and in particularly social justice, as we found under Article 46 of the Directive Principles of State Policy, which provides for promotion of educational and economic interest of scheduled caste, scheduled tribes, and other weaker sections. So, in this regard, the state shall promote with special care the educational and economic interest of the weaker sections of the people, and in particular of the scheduled caste and scheduled tribes, and shall promote them from social injustice and all forms of exploitation. So, this particular article which provides for social economic interests to be protected and promoted by the state, and in that regard the state enacted many laws for bringing social and economic justice and in removing all kind of discrimination, exploitation, and inequality prevailing among the socially and economically backward classes, in particularly the scheduled caste and scheduled tribes population in India. And in that regard, we would like to discuss the fundamental rights which are enshrined under Part 3 of the Constitution, and in particularly the Article 15 under Clause 3 provides that the state can make any special provisions for the advancement of any socially and educationally backward classes of citizens or for the scheduled caste and the scheduled tribes. Also, Article 15 Clause 4 provides that nothing in this article shall prevent the state from making any provisions for women and children to provide social and economic justice. Also, Article 15, Clause 5 itself also provides the state that for making any special provisions for the development and advancement of any socially and educationally backward classes of citizens, including the scheduled caste and scheduled tribe population. And also, as we found under Article 16, it also provided that the state should bring out legislations for providing equal opportunity in matters of public employment. So, in that regard, the state shall make provisions for equal employment opportunity, and in that regard, it provided that the parliament for making any law and prescribing in regard to a class or classes of employment or appointment to an office under the government of India or government of a state or any local or authority. So also state can make any provision for reservation of appointment or post in favor of any backward class of citizens. So these provisions of the Constitution provides protective discrimination. So although it is prohibited any kind of discrimination but for the upliftment and advancement of certain classes which are socially, economically, and educationally backward, or such classes, the scheduled caste and scheduled tribes, for their upliftment and advancement, the state and parliament can make any special law and provisions for their development. And in that regard, also, besides educational institutions, in other fields such as employment and promotion, the state could make any special provisions for their advancement and upliftment. And in that regard, the 77th constitutional amendment, which provided reservation in the field of promotion in regards to those employees working either under the union or state or in any local or any authority in regards to their promotion. And also the 81st constitutional amendment provided that any unfilled vacancies remained, then also the state can make any provisions in accordance for reservation for the advancement of certain classes. So also the 103rd constitutional amendment, which was enacted in 2019, it also provided that the state could make any laws for the reservation of educational institutions and even under employment for those classes which are economically considered as weaker sections. So also we found there are certain other constitutional provisions which provides also in regards to protective discrimination. And in that regard, we could examine the provisions of Article 330, which provides reservation of seats for scheduled caste and scheduled tribes in the House of People. And in respect to state legislative assemblies, Article 332 of the Constitution provides reservation of seats for scheduled castes and scheduled tribes in the legislative assemblies of the states. And besides that, another important provision under Article 335 of the Constitution, which provides that claims of the scheduled caste and scheduled tribe population who are socially, economically, and educationally considered as backward, so their claim in regards to any kind of service or post under this union or the state, in that regard also the state could make reservation for those particular backward classes like the scheduled caste and scheduled tribe in regards to their claim for any post or service under the union or the state or under any local authority or any other authority. And to fulfill these dreams of bringing and social and economic egalitarian society where social justice and economic justice could meet all the demands of those weaker sections. In that regard, the state also made enactments, and in particularly in regards to the provisions of the Constitution of India under Article 335, the Parliament constituted National Commission for Scheduled Caste, and under Article 338A, National Commission for Scheduled Tribes, and under Article 338B, National Commission for Backward Classes. Also, under Article 340 of the Constitution, the provision relating to appointment of a commission to investigate the condition of backward classes. So these provisions under the Constitution of India clearly demarcated that in spite of these discriminations, there is an aim to bring out an egalitarian society where there would be no exploitation, no inequality, and there would be a equal social order, and everyone will get social justice and economic justice. So, in that regard, we would like to discuss certain important landmark judgments. So, in that connection, we would like to discuss first the most important judgment relating to this is the important leading case of 1992, and that is Indra Sahani versus Union of India. So, in that particular case, a new concept developed by the apex court, and that is the creamy layer. So, in Indian politics, the term creamy layer refers to some members of a backward class who are highly progressed socially, economically, and educationally. They are the most forward thinking members of that backward classes. Members, the word was first used in this particular important leading case And this concept of creamy layer is only applicable to the other backward classes, those who are advanced among those backward classes as they are forward thinking, and this concept of creamy layer would not be applicable in case of scheduled caste and scheduled tribes. And the second important leading case that we would like to discuss in connection to protective discrimination is the leading case Mohan Kumar Singhania case in 1991, where the Supreme Court explained that Article 16, Clause 4 is an enabling article that gives the state freedom to make any provision or reservation for any backward classes of citizens that is not adequately represented in the services of the union or state or any local authority or any other authority. So, the state or the union government takes the total population of the backward class and their representation in such services and posts under the union or state or any local authority or any other authority, and regards to that with appropriate calculation of their representation in such posts and services, then the parliament can make the reservation and provides the very percentage of reservation for such post. And in that regard, the apex court expressed that such kind of reservation for such backward classes with appropriate calculation, and it must be done very carefully. Then only it would fulfill the aim of social justice and economic justice. And in this connection, we would like to discuss another important leading case, and that is the case of All India and Dravida Munnetra versus Union of India in 2020, where Supreme Court refused to accept a series of petitions demanding the implementation of a 50% reservation for other backward classes in state-funded seats in the All India Court of Art, undergraduate and postgraduate medical courses in Tamil Nadu, stating that reservation is not a fundamental right. The apex court has held multiple times that year in a series of decisions that reservation was not a fundamental right. Hence, the right to receive reservation in the posts and services under the union or states and educational institutions run and funded by the state, either union or any state, and under various other organizations such as the urban and rural local authorities, is at the discretion of the lawmaking bodies, that is the Parliament of India or any state legislative assembly, and not a permanent right. As it is not a fundamental right, so it is not a permanent right which people from the social and economically backward sections of the society could demand. So, This is one of the landmark judgment made by the apex court in regards to protective discrimination in relation to the very demand in regards to such posts and services under the union. So now we would like to conclude our discussion on protective discrimination. So the Constitution of India provided various laws, in particularly those provisions that we have already discussed, those provisions under the fundamental rights, which is ancient and part 3 of the Constitution, and in particularly Article 15, Clause 3, Clause 4, Clause 5, and Article 16. And also we have discussed the provisions under Article 46 of the directive principle of state policy in regards to provide social justice and economic justice. And that also we have discussed in relation to Article 330, Article 332, and also Article 335. And besides that, also we have discussed the Constitution and establishment of National Commission for Scheduled Caste, National Commission for Scheduled Tribe, and National Commission for Backward Classes as provided under the Constitution, in particularly under Article 338 in regards to National Commission for Scheduled Caste, and as regard to National Commission for Scheduled Tribes as provided under Article 338A, and also another commission for backward classes under Article 338B, which is otherwise known as National Commission for Backward Classes. So, all these provisions, and besides that, the landmark judgments, in particularly in the Sahani case of 1992, which defined what exactly creamy layer means and how it could not be applicable in the case of reservation for scheduled caste and scheduled tribes, and it would only be applicable for the other backward classes. And also, we have discussed the decision of Mohan Kumar Singhania case of 1991 and the most important landmark judgment delivered by the apex court in the leading case All India and Dravida Munitra Khazgam versus Union of India in 2020, which was relating to 50% reservation, and particularly in regards to postgraduate and undergraduate courses in medical institutions. So almost we found that in particularly a vibrant and vigilant democracy always needs the egalitarian society where there would be no discrimination, no exploitation, no equality, and it would only not achieve social justice and economic justice. It would also make possible for a true democracy and a political society. So, only it could be possible by removing such exploitation, inequality in any field, whether it is in social field or economic field or even in political field, and in particularly by removing all social evils and prohibiting all kinds of discrimination, such as a social evil that we found under Article 17 of the Constitution, which deals with abolition of untouchability, as we know the Indian society was suffering from many social evils which made the society an unequal order, where we found there was lack of social justice and economic justice. So, in that regard, the very provisions that we found under Article 15 and Article 16 and regarding the constitutional amendments of the 77th Amendment and also the 81st Amendment and the last one, that is 103 Constitutional Amendment Act of 2019, we found the very objective and aim of the Constitution of India to bring out an egalitarian society where everyone would get social justice and economic justice. Besides that, the democracy of India would be a vibrant and functioning democracy with political justice.